Welcome everyone to our webinar on your advertising compliance as a real estate agent. My name is Saya and I am a lawyer in LegalVision's commercial contracts team. I'm joined today by my colleague Ushna, who is also a lawyer in our commercial contracts team. Before we begin, a couple of quick housekeeping items. So you'll receive the recording and slides in your email after today's webinar ends. Please submit your questions in the chat box and we'll answer them at the end of today's webinar. And finally, please complete the feedback survey after the webinar ends. Also, all attendees are eligible to receive a free consultation with us to discuss how we can help you with your real estate or advertising requirements or any of your other legal needs. To request your free consultation, provide us with your contact details in the survey that appears at the end of this webinar. Here's an overview of what we will be discussing today, and I'll now hand over to my colleague Ushna, who will tell you more about today's webinar.
Hi everyone, thank you so much for joining us today. So today we'll be talking about how to ensure advertising compliance as a real estate agent. When we use the term real estate agent or agent in this webinar, we're generally referring to real estate agents, buyer's agents, seller's agents, and property managers. As you already know, an effective advertising strategy is critical for marketing your real estate business, client properties, and your real estate business's long-term success and growth. However, it's essential to ensure that your advertising practices are effective, accurate, and lawful. In this webinar, we will touch on advertising practices you should avoid to ensure compliance with real estate legislation and your general obligations under the Australian Consumer Law with respect to advertising. I will now hand over to my colleague Saya, who will kick things off by discussing your obligations under the Australian Consumer Law.
Thanks, Ushna. As a real estate agent, you need to ensure that all of your marketing and advertising complies with the Australian Consumer Law. The Australian Consumer Law prohibits a person or business in trade and commerce from engaging in misleading or deceptive conduct. This prohibition applies both to intentional and unintentional acts or statements. The key consideration when deciding if conduct is misleading or deceptive or is likely to mislead or deceive is whether the overall impression created by your conduct is false or inaccurate. For example, you cannot advertise a property as being 5 bedrooms when it is only 4 bedrooms, or move-in ready when it needs significant repairs. Further, you must avoid making false or misleading representations in your property advertisements, including that regarding the nature of the interest in the property, the price payable for the property, the location of the property, the characteristics of the property, or the existence or availability of facilities associated with that property. You must also ensure that any claims made about any property or land characteristics in any photos and advertising are accurate and do not give prospective buyers the wrong impression. Any statements paired with photographs of the views and facilities available in a local area, for example, must not be false or misleading. Now, whether conduct is misleading or deceptive will depend on the factors surrounding the conduct. Many circumstances will be taken into consideration, such as the entire advertisement or statements made by the agent. Fine print, contradictory statements, and images that obscure or alter written statements are all taken into account when making this assessment. The ACCC, together with the state and territory consumer protection agencies, enforce the Australian Consumer Law, and substantial financial penalties can be imposed depending on the nature of the contravention.
In addition to the general obligations under the Australian Consumer Law, real estate agents are regulated under specific state and territory legislation and related regulations. Under this framework, real estate agents must comply with a suite of requirements, including, but not limited to, professional conduct standards, licensing, and the form and content of agency agreements. In addition to this, the framework also covers permissible and non-permissible advertising. As mentioned earlier in this webinar, the laws and regulations are state and territory specific, And so for the purposes of this specific webinar, we'll discuss the framework more generally. If, however, you do want specific advice about the jurisdiction that you're operating in, please feel free to reach out to us after this webinar for a consultation, as mentioned earlier by my colleague Saya. I want to specifically note that what an agent can and cannot do, known as the agent's authority, is established in the contract between the agent and the client, known as the agency agreement. An agent does not have an automatic right to advertise a property on behalf of a client. Rather, this right needs to be explicitly granted and outlined in the agency agreement. The agency agreement should also cover matters such as any marketing fees the agent can incur to market and promote the property, where the property can be listed. For example, is it just on one exclusive platform or a range of different platforms? Any photography fees that the agent can incur, details of showings of the property. For example, what days and times can these showings occur? How many showings will there be? Are there any specific rules around these showings? And also the price range that you can advertise the property for.
Thanks, Ushna. I'll now touch on your professional obligations as an agent. Agents have a fundamental obligation to be truthful and honest in their work. This obligation extends to advertising and includes accurately representing the features, condition, and price of a property. Visual representations, including photographs and floor plans, must accurately represent the property, and any digital manipulation or enhancement should not distort the property's true features. When using photographs as part of the property advertisement strategy, you must not use photos that provide a false impression. For example, using photographs that have been manipulated to hide or include features such as hiding a power pole or including trees to cover a neighbouring property, imply that a property has parking when it does not, or are accompanied by statements that imply the property has beach views when it does not. Exaggerating a property's size, concealing defects, or using deceptive language to describe a property are not only unethical, but also against the law. Importantly, an agent may be found guilty for misrepresentation, whether or not it was their intention or in their knowledge that a misrepresentation was being made at the time an advertisement was being published. Further, agents have a fundamental duty to be ethical. If you have a relevant interest in the sale of a property, you must not publish any advertisement relating to the proposed sale unless the relevant interest in that property is disclosed in the advertisement itself. But what is a relevant interest, you might be wondering? A relevant interest can include ownership interests, such as if you or your family have a direct ownership interest in the property being sold, or, for example, a financial interest where you have a business relationship with a third party who has a relevant interest in the property. In addition to this, any testimonials published on the agent's website or which form the agent's marketing materials must be genuine. False testimonials can be considered misleading. So, for example, you cannot publish a quote that was never actually provided to you, or publish a quote that has been altered. You also cannot pay anybody or offer them any benefits in exchange for a testimonial. I'll now discuss penalties. You may incur severe penalties for failing to comply with your professional obligations under relevant real estate legislation or the Australian Consumer Law. In relation to a breach of the Australian Consumer Law, you may be penalised up to $1.1 million if you are incorporated as a company, or $220,000 as an individual. In relation to a breach of relevant real estate legislation, there are a range of penalties. So, for example, you may receive a written warning about your conduct, be issued a directive which requires you to take a particular action within a particular time. For example, be required to remove an advertisement or amend it. You could receive a financial penalty. You could have a condition imposed on your license. You could have your license suspended or disqualified, or where you perform management functions, be disqualified from performing those functions. In addition to this, the relevant regulator may issue a public warning about the risks of dealing with you in response to your conduct. The aim of such a public warning is to protect consumers from significant loss or harm from dealing with an agent who does not comply with their professional obligations.
Thanks, Aya. I'll now be talking about the disclosure of material facts. As you may be aware, agents also have an obligation to disclose material facts whilst advertising a property. So what is a material fact? A material fact in the context of real estate refers to important information that would influence a reasonable person's decision to proceed with a property transaction. It includes facts that are significant enough to affect the decision to buy, sell, or rent a property, and could impact the market value of a property. Real estate agents have a duty to discuss and disclose such facts when marketing a property. Importantly, an agent could still be in breach of the law for failing to disclose a fact even though they actually didn't know about it. Some of the material facts that are actually prescribed by regulation include information pertaining to flooding, health or safety risks, asbestos insulation, crime history, drug-related activities, and the presence of combustible cladding. Failure to disclose any of these facts will amount to a breach of the agent's professional obligations. Agents should make reasonable inquiries with property owners to determine if any material facts apply to a property. Some material facts, such as those relating to external combustible cladding, for example, would be known by the property owner and revealed by prospective property purchasers doing their own due diligence in getting copies of the strata owners' corporation records. However, if an agent has those strata records and they contain information relevant to those material facts, the agent must disclose them. It's unlikely that an agent would be held liable for not disclosing a material fact if the vendor intentionally concealed that information from the agent when they were questioned about it, and the agent could not otherwise be reasonably expected to know that information. However, it's important, and we highly recommend that you also include a clause in the agency agreement relating to material facts, whereby the property owner confirms that they've disclosed all material facts to the agents. I'll now pass back to Saya, who's going to be speaking to you about representations as to selling price.
Thanks, Ushna. An agent must avoid deceptive pricing practices, such as pricing a property below market value to attract buyers. This is known as underquoting. So, for example, you cannot advertise a property for $800,000 if you know the seller is only willing to accept offers starting at $1 million. Or you cannot advertise a property as being price reduced when you have never listed the property for sale at a higher price. In addition to this, an agent cannot publish an advertisement in relation to the sale of residential property that indicates or suggests a selling price for the property that is less than the estimated selling price. For example, you cannot publish an advertisement which states the selling price for a particular property is $750,000 when the estimated market selling price is closer to $1 million. An agent also cannot publish a selling price that is less than the price proposed in any written offer rejected by the property owner. And where the estimated selling price for a property is amended, an agent must take all reasonable steps to amend or retract any advertisement published in relation to the property. In some jurisdictions, this must be done within 1 business day, so it's important that you are familiar with your obligations under the relevant state and territory laws.
Real estate agents in Australia must also ensure that their advertising practices comply with anti-discrimination laws. So generally, this means avoiding any languages, images, or statements in property listings and in advertisements that could be seen as discriminatory or exclusionary. Agents should promote properties to a diverse range of potential buyers or renters, and where possible, you should ensure that any open homes are accessible and open to all.
Thanks, Ushna. I'll now discuss public advertising and what details you need to include when advertising. In Australia, there are no national regulations governing how long a real estate agent can leave a for sale or similar sign in front of a property. Signing regulations actually vary by state or local government, so it is important to check with the relevant state or local authorities to determine the specific rules and guidelines in the local area where you are advertising the property. Some local councils may have specific time limits, such as requiring the removal of the sign within a certain number of days after a property is sold or leased. You must ensure that you are always advertising in compliance with these guidelines, and you can ensure that you do this by consulting with your local council or regulator to get access to access accurate and up-to-date information regarding public advertising. Further, an agent cannot publish any advertisement unless the advertisement includes the licensee's name, and this applies to both online and offline advertising. If you are incorporated as a corporation, you must include the corporation name. Further, all advertisements must include details sufficient to advertise the agent. And this means, at a minimum, you must include the agent's full name and contact details, along with the name of the business for which the agent works. This will help customers verify the legitimacy of the agent.
Thanks, Daya. Look, we all know that advertising is key to having a successful business as a real estate agent. However, along with making sure your advertising is catchy and capable of selling or leasing a client's property, you really need to make sure that it's legally compliant. In this webinar, we've outlined some of the key things you need to be aware of when advertising to ensure that you're complying with the legislation and regulation governing real estate practice. In particular, you want to ensure that when advertising, you're not making any false or misleading representations. You're complying with the requirements outlined in your agency agreement. You act in accordance with your professional obligations, including being truthful and honest and revealing any conflicts of interest. You disclose any material facts to buyers. You avoid deceptive pricing practices, and you comply with anti-discrimination laws.
Great, thanks, Ushna. Now that concludes the main part of our webinar. You might find our publication useful, our Real Estate Advertising Compliance Fact Sheet. You can access this in the handout panel or by scanning the QR code on the slide. We also have an upcoming event that may be of interest to you on protecting your brand, most commonly asked questions about trademarks, that will be held on Wednesday, 15th November at 11 AM Australian Eastern Daylight Time. You can register at the link on the slide. We're going to answer your questions shortly. While we give you the opportunity to submit them, we'll take a minute to tell you about our membership. LegalVision's membership is a cost-effective alternative to have all of your business as usual legal needs covered. For a fixed monthly fee, you not only receive cost certainty, but also all-inclusive benefits, such as unlimited document review, which would include reviewing your commercial contracts, unlimited consultations, which means you can book as many meetings with us as you need to discuss your agency agreements, licensing requirements, and other business as usual needs. You can talk to any of our lawyers, including franchising, corporate, employment, depending on your business's needs. Your membership offers unlimited trademark registration as well. Think of it as having your own in-house counsel. We'll take care of all of the business as usual legal work so you can focus on running your business. And if you are in-house counsel, our membership is a cost-effective solution for outsourcing additional legal work. To learn more about how our membership can help you, you may request a free consultation when the survey appears at the end of this webinar. Now, we're going to answer your questions, and I think we'll get started with Ushna.
Thanks so much for submitting your questions. We've had a few come through, so we'll just filter through them and take them as they come. But one of the first questions we got asked was, is there a case where an agent or agency has breached and was penalised for misleading advertising in recent years? So thanks for sending that question through. Look, there's been a range of cases over the years, but a recent one is actually from 2023. So this was in Victoria, and a real estate agency was actually ordered to pay more than $6,000 in compensation by the Victorian Civil and Administrative Tribunal because they advertised a house as having air conditioning when it didn't. So that just kind of goes quite in line with the examples that Hussain was pointing out about making sure that any information that you put on the listing is actually quite true and accurate, because yeah, you can be slapped with fines kind of upwards of $6,000, and yeah, these things are definitely happening, so you really want to make sure that you're complying with any obligations in under the Australian consumer law, or any kind of rules that have also been outlined in your specific agency agreements with your client.
Thanks, Ushna. I've got another question here. Question we have is, how do we handle situations where a client insists on making false or misleading representations in their property listings? So this is a little bit of a difficult one. I guess it comes down to managing your customers' expectations about what you can and can't do legally and in accordance with your professional obligations. We would always recommend emphasizing to your client that you have obligations at law and that you cannot make any false or misleading statements. You can also explain that you would be in breach of your professional obligations, and also point out the consequences for non-compliance, which I raised earlier in this webinar, which does include suspension or termination of license. You can also outline some of the consequences of some of the other consequences, such as the financial penalties which may apply, and also the public warnings that can be issued to customers about working with you. If they continue to insist, we of course would recommend never to make any false or misleading representations, and you might consider whether you want to continue to work with this client and if they're a good fit for you and your business.
Thanks, Aya. So I just had a question come through, which somebody's asking, at what point should we be disclosing the material facts? And I can definitely appreciate that this is quite a complex area because of the kind of range of material facts that you need to be disclosing as well. And I did mention earlier that real estate agents have to be really careful because you could be penalised for not disclosing a fact that you weren't even aware of. So the onus is really on you to make sure that you're making those reasonable inquiries and then, disclosing those relevant facts to potential buyers at the right time. Look, I guess it really is quite at your discretion, but I would say that it depends on how sensitive that fact is. So, if it's just like kind of general information about the property, for example, the land size that the property is on, how many bedrooms it's got, for example, those kind of things you will probably be disclosing at those initial showings to anybody that asks you those questions. But then when it comes to facts that are a little bit more sensitive, say, for example, any crime or drug history that might be associated with the property, those are probably not conversations you're going to be having with prospective buyers, the minute they walk through a door at a showing. So you really have to use your discretion about when you want to be disclosing that. But I would probably be kind of letting those individuals know when they start showing a little bit more interest in the property. So say if they're calling again, definitely if they're putting an offer through, you want to make sure you're disclosing those facts before they do that. So yeah, it's a very it's a bit of a tricky one, but just make sure that you're doing your job by putting all that information to them so that they can make an informed decision when they're making that purchase.
Great, thanks, Ushna. We've got another question here. The question says, what laws do I need to comply with if I run my real estate business in multiple states? This is a good question. As we mentioned earlier in this webinar, real estate legislation in Australia is state and territory based. So each state and territory has their own separate real estate legislation. This makes things a little bit more complicated where you are running your business in more than one state, so multiple states and territories. You will need to ensure that you're complying with the applicable advertising requirements and real estate legislation for each state and territory where you are running your business. So it's really important that you are across what those obligations are, because obligations can vary depending on the state or territory you're operating in. I will note, however, that the Australian consumer law applies to all jurisdictions. It is national law, so the provisions that we discussed today about misleading or deceptive conduct will apply to you in all of the jurisdictions where you are operating, so that's Australia-wide. We would recommend booking in a consultation with us to discuss the different jurisdictions where you operate your business, and we would be able to provide you with advice about what those obligations are and how to go about running your business in those different states.
Thanks, Aya. So somebody's also asked, what are some of the penalties for making false or misleading representations when you're advertising? So, you know, like I mentioned in an earlier question, there was a real estate agency that was fined over $6,000 in Victoria for making false or misleading representations. So there's a range of penalties, and there's also different legislation that deals with it. So, you know, as we outlined, there is the Australian consumer law, and then there's quite specific legislation that varies from state to state. So I won't be going through each of those specific legislations, but, you know, just generally, for example, under the Australian consumer law, the maximum penalty in the case of an individual who makes a misleading or deceptive representation is $220,000. And for a company, it's 1.1 million. So it's extremely high. And, you know, there's just to cite like a specific legislation in the real estate industry, the Property and Stock Agents Act. Under that as well, you know, a person can claim damages or other compensation in respect of misrepresentation or concealment. So those are things to think about. And then I guess, you know, another key issue is that your license can also be suspended, which is quite serious. And I'm sure nobody wants that. So yeah, look, really important again to make sure that you're complying with those regulations, that you're doing your best to make sure that your advertisements are truthful and honest, and you're dealing with those prospective buyers. You're really making sure that they have all the information that you know, a reasonable person might want to know before they're making a purchase. And then, yeah, look, if you're ticking all those boxes, you should be good. But I guess in summary, there are pretty steep penalties for not complying.
Thanks, Ushna. We've had another question come in. What happens if you have a buyer who asks you a question about whether someone has died in the property, even if it is of natural causes? I know that this isn't part of the material facts. This is a bit of a complicated question. Typically, you will need to disclose whether somebody has died in a property if, for example, it was related to some criminal activity. It's not very clear whether you would need to disclose whether somebody dies of natural causes. However, what constitutes a material fact to different buyers would be different, and we would recommend, in the interest of transparency, that you are disclosing deaths, even where they are of natural causes, just to ensure that there's never any dispute about any sort of misleading or other claims that you have sort of withheld any information that would be important to a buyer. So we would recommend disclosing those facts, even if they aren't part of the material facts that are specified.
And also, just to add to that, you know, I appreciate that kind of information, especially if people have died of natural causes, might not really readily be available to you. So it might be quite difficult to even kind of get your hands on that kind of information. So it's always perfectly fine to let the buyer know that you don't have that kind of information at this stage. You're happy to kind of, you know, do some digging and see what you can find. But ultimately, as long as you're doing your best, you're doing your due diligence and making those reasonable inquiries, then you know, you're ticking off the boxes in terms of your own obligations.
Yeah, absolutely.
I've actually just had a question come in that's a little bit more pertaining to the actual membership, which I'm happy to answer. I know I kind of touched on it a little bit, but somebody's asked kind of how we work in terms of contract reviews. So is there a cap to the number of contracts that we might review for you, for example, your agency agreements? So happy to talk a little bit more about that. It is an unlimited document review, which I know sounds too good to be true, but it's the way that we work. So Saya and I are both in the commercial contracts team, and that's kind of what we do day in, day out. So practically how that works is that For example, you might have an agency agreement that comes through that you're wanting reviewed. You would just upload that into our customer-facing system, which is called Prism. We would have a call with you just to get some background information, understand the kind of intricacies of your relationship with the other side. And then, yeah, we take it away and we can mark it up for you. And our turnaround is, 3 business days, 3 to 5 business days. So we're really quick at getting those things across to you. You're not waiting months, as is the case with kind of traditional lawyers. So yeah, it is unlimited document reviews. It's not just limited to reviews. We can obviously also do drafting, which is really handy. So what that means is that if you're wanting your own agency agreements drafted, your own customer agreements drafted, we could draft those from scratch. We have a whole range of clients in the real estate industry. Sayed's a bit more of an expert in the industry, so feel free to add anything else, if you want. But yeah, that's the nature of membership. It's really good because you're not then paying on a per project cost, which can become really, really expensive. You're paying a weekly fee, and kind of across that year, that ends up being so cost effective for you.
Thanks, Ushna. We've got another question here about the detail required in the agency agreement, particularly in respect of advertising and getting that authority to advertise on behalf of a client. It's really important that the contract between you and your customer is very clear and detailed about what your authority is. So we would always recommend including as much detail as possible to avoid any misunderstandings about the parties, that, for example, you as the agent incurred additional costs that you weren't actually authorized to incur in respect of advertising, or that, for example, you didn't advertise the property enough. So we do recommend, as best practice, always including a lot of detail about what you are actually going to do for that client, what your advertising strategy is going to be. And of course, as Ushna pointed out, you cannot advertise on behalf of your client without having their written authority in your agency agreement. So it's not an automatic sort of given that's granted to you because you are their agent. It does need to be explicitly and expressly outlined in writing and agreed between the parties. So that's probably the most important starting point for beginning the advertising strategy for your clients, is ensuring that your agency agreement is very clear about what that is going to look like. And as part of the membership that Ushna was just touching on, we can assist you with the drafting of your agency agreement. We can also assist with the reviews of any agency agreements that you are looking to execute with a prospective customer. It's always good to double check that your agency agreement is in order to avoid any of the misunderstandings and disputes.
Thanks, Saya. Another quick question, which is going back to the disclosure of material facts. One of our viewers has asked kind of how much of the onus is on the prospective buyer to be making their own inquiries about property. Look, I guess there's no kind of black and white answer to this. As the real estate agents, you obviously know more about the property than the prospective purchaser does. And like I mentioned earlier, the onus is really on you to be making those disclosures. Of course, there is a sense of responsibility on the prospective buyer's side as well, that they're not going into it completely blind, and they should be kind of making their own inquiries. A good example of this actually is in the case that I mentioned earlier, where the real estate agent was fined in March. The lawyer for the real estate agent tried to argue actually that anyone looking at the house would have seen that there was no refrigerated cooling unit. And so they tried to argue that it was actually the purchaser's own fault because they didn't observe the property properly. And just to remind you, that case was about the fact that they had advertised that the house has an AC unit when it actually didn't. And then the purchaser kind of purchased the property based on that representation. So, that's just a clear example of the fact that you can't be advertising a property as having a specific, inclusion and then trying to put that on the buyer that they didn't look hard enough and didn't notice that inclusion was missing. So I guess the answer is yes, you should. There should be a sense of kind of reasonableness coming from from the buyer's perspective, where they are making those inquiries, they are attending showings, but at the end of the day, the onus really is on you because you've got the higher bargaining power here, you're selling that property to them. So I really would not be relying on the purchase in this instance, and I would be making sure that I'm doing my job properly.
Perfect. We've got another question that's come in. It's what requirements do people who are advertising leases privately, where they are the landlord, have to be aware of? This is a good question. Today's webinar was focused on where you have a real estate agent acting for you. We'd be happy to discuss the specifics of this arrangement. So we would recommend that you book in a consultation with us after today's webinar, and we'd be happy to discuss the specifics there. In summary, you would still need to comply with the Australian consumer law, and the provisions discussed today about misleading and deceptive conduct would apply to you. So you would need to ensure that you are advertising the property truthfully, that you're not making any misrepresentations about the property, any photographs that you're using are accurate and actually reflect what the property looks like, that you're not concealing any parts of the property or claiming that the property has more facilities than it actually does. But yes, please do book in for a consultation with us, and we would be happy to discuss this further with you.
Thank you, Sai. We've had a question come in where somebody's asked where they can actually access the case that I was talking about earlier. So, I mean, we internally have access to platforms. I'm not sure whether you'd be able to access it, but for this particular case, I've also just had a quick Google to see whether it's publicly available, and it is. So, I think if you just do a quick Google of, Victorian Civil and Administrative Tribunal real estate agency fine, there's a few news articles that actually pop up that talk about it, and they outlined the specifics of what's happened. And I think there was actually it went over 2 years, so you should be able to get access to that case. I'm a bit hesitant about specifically naming the parties in this instance. So yeah, if you just do a quick Google, you should be able to get access to that information. I've just had a look, and it's all publicly available. So yes, and I think that's probably the last question that we've got. We might just wait a moment and see if there's anything else that comes through, and then we can wrap up.
Yeah, as we said, if you didn't get a chance to ask any questions, or any questions come to you after the webinar, please feel free to book in a consultation with us, and we'd be happy to assist. Now, that's it for today's webinar. After the webinar ends, a survey will pop up, and we would really appreciate it if you could complete the 30-second survey. Please include your contact details to receive a complimentary legal consultation to discuss how we can help you with your advertising needs and your real estate business, and we'd be more than happy to assist. Thank you so much for joining us today.